Statebased?
There's been a lot going on in the last year or so with respect to our criminal justice system and the spotlight that's been on it. And it was important for us to have an opportunity to have a constructive dialogue where we can actually talk about and discuss these issues in a positive manner, because the goal is sustainable change. The goal is actual reform, and we hear enough of yelling and demonizing one another. But we wanted to have an opportunity to have a constructive dialogue and set a tone of civility as we discuss our criminal justice system. So that's the idea that we had going into this. My name is Wesley Bell. Along with Rachel DeShine and several others. I was part of the planning committee. I'm also one of the new Ferguson City councilmen, I should say. I also teach at St. Louis Community College, the Florissant Valley campus. And we want to welcome you for being here, obviously, taking time out of your day to come so we could to have a program like this, which I think is so important. Also, while I'm thinking about this, we encourage you to tweet. We want to get the word out. So if you can hashtag for you tweeters, MOCJ Reform. If you want to tweet something, add that hashtag as well as tagging the Liberty and Ethics Center, which will come up which will fill in if you tag it. So at this time, I want to introduce the chair of our planning committee, Professor Rachel DeShine, a professor of philosophy here at the college at Lindenwood, my alma mater, which I'm proud of. And then we're going to get going with our panelists. So again, thank you for coming, and we appreciate you.
Thanks, Wesley. If you're wondering why this isn't amplifying, it's because it's for the recording, not for you all. You all can hear me just fine. I'm Rachel DuChant. I'm director of the Liberty and Ethics Center. I'm really privileged to have you all here. I know a lot of people are looking for parking, so there'll be people streaming in throughout the hour. But it's such a privilege to have you here because this issue affects our daily lives in such a deep and serious way. And the Liberty and Ethics Center is interested in free and virtuous society. And one of the worst forms, of course, of state oppression is unjust imprisonment. So it's really important that we address this. Other than that, I just want to say @LibertyEthics is my Twitter handle. So go ahead and shoot me a tweet at #MoCJReform. And if you want to add on #MoLeg, that's the Missouri legislature. So you might encourage your representatives or state senators to take a look at what we're talking about here today. The only other thing I have to say is just how thankful I am to St. Louis Community College at Florissant Valley. We've partnered up with them in a number of ways. We're working on listening circles that bring police officers together with students. They're teaching us how to run those listening circles so that we can bring them out to St. Charles. And here to sort of represent that partnership and to introduce our first panel is the interim president of St. Louis Community College at Florissant Valley, Ruby Curry. And the one thing I want to say about Ruby before she gets going is just that she is retiring, and we're not happy about that. So we're going to miss her very much. So I'll hand it over to Ruby, and then Wes and I will go get the other session started, and we'll get rolling. Thank you so much.
Thank you, Rachel and Wesley, and we're so proud to have the opportunity to co-host, co-sponsor this afternoon's events, and to let you know that many of the volunteers that you see are from St. Louis Community College, and we did have students that were part of the planning session as well. Our focus for this afternoon's session, session 2, is the prison system. And so I'm going to talk about in the first session, which you're sitting in now, we'll be talking about mandatory minimum sentencing, and we have T.R. Carr Jr., and we have Mr. Craig Newbern, and both of them will give you a little bit more about their background for sitting on this panel. And then in our 3 to 4 panel will be sentencing alternatives, Nancy McCarthy, Jason Cleveland, Doug Burrs, and Dr. Rance Thomas. And then at our 4 o'clock session, we're going to talk about reentry, and those panelists will be Barbara Baker, Carrie Pettis Davis, Les Johnson, Aaron Laxton, and LaRonda Wilson. And so you should know this is going to be a free-flowing. There'll be some questions directed towards you, and then an opportunity for you to ask the panelists questions, the experts. I'll give you the education side of what I think, and then the others, they'll give you the more what they think. So starting with T.R. Carr, would you please tell us a little bit about yourself?
Oh, thank you. I retired from Southern Illinois University, Edwardsville, the 1st of January of this year. I had served as chairman of the Department of Public Administration Policy Analysis for some 15 years. I also served 3 terms as mayor of the city of Hazelwood from 2000 to 2009. We have a council manager form of government, so I did that while I was at SIUE. I was appointed by Governor Nixon to serve on the Ferguson Commission, and we're winding down our work at the present time. And I also serve as vice chairman of the St. Louis County Police Board. So I have a number of different perspectives. One project that we're involved in through St. Louis County is we're working with the MacArthur Foundation, a Safety Plus Justice grant. This grant, 200 governmental entities applied across the country. 20 were selected as part of the planning process. 10 will be selected for an implementation of upwards of $10 million over 4 years, 5 years. This grant is designed to reduce unnecessary incarceration. We're not necessarily talking about prisons at the municipal and the county level, but we're talking about jails. We have a lot of people that spend too much time in jails for minor reasons. I attended a conference in Chicago. To put this in perspective, one of the individuals said, we have to put people in jail that we're afraid of, not that we're mad at. And a lot of times people go to jail, municipal jails, county jails, historically, because we're mad at them, not because they deserve to be in jail.
Hey everybody, my name is Greg Newbern. I'm the State Policy Director for Families Against Mandatory Minimums, which is a nonprofit group based in Washington, D.C. We focus on sentencing reform at the federal level and the state level. I do most of the state policy work. I work primarily in Florida, where we've had a full-time project for about 5 years now. Florida is my focus state, but if the issue comes up in other states, I try to work in those states as well. Done work in quite a few states actually at this point through the years, and Missouri is certainly one of the states that we're starting to focus on. So happy to be here, and we'll talk more about state policy work, I'm sure, as the day goes by. I went to undergrad and law school at the University of Florida. I'm a native Floridian, was born and raised there. Went to D.C. for a year and worked at the Cato Institute, came back, didn't want to practice law at all, so I taught high school for 4 years, which was amazing. Loved that job, and if I wasn't doing this job, I would be doing that job still. But I've always been passionate about sentencing reform and criminal justice work and trying to make the system better. So when this job came along, I was sad to leave the teaching profession, but very happy to take on this job as well. And feel like we've done some pretty good work, and we're going to keep going. So looking forward to this.
All right, thank you. And again, my background has been in higher education, and I'll say this real fast, 39 years, and I started when I was 15. And through the stresses of education, that's why my hair is white. But anyway, I will come from more of a standpoint of, as we allow, as you know, President Obama has talked about will be releasing. I just so happened to hear a radio station where they were interviewing police chiefs, and they gave all the reasons why we shouldn't. And I'm coming with the fact that, yes, when we do allow for those folks to be released, then we need to have something in place for them. And one of the things we must have in place is an educational system, housing system, and employment. So that will be the viewpoint that I will come from if interviewed. So TR, I'll let you kick it off.
What we're planning on doing, I am not an expert in terms of mandatory prison sentences, but we'll be engaging in a series of questions. At the same time, we'll endeavor to take a few questions from you if you want to have questions about it. So we'll begin. What we might do is begin by your assessment of the changes that are occurring in federal mandatory sentencing. I know that the news media is reporting that, 7,000 individuals are being released early. Would you give us your
Sure.
insights on what really is happening there?
Yeah, there's been some misreporting about that story. If you've seen the headlines, President Obama is releasing 6,000 offenders tomorrow. The truth is, yes, there are 6,000 people who are going home, but it's been part of a long process. Most of them have been in halfway houses for months. They've been involved in reentry programs, and the utter commonality of this event, I think, has been lost in most of the press. tens of thousands of drug offenders are released every year. This is just what happens when the sentences are when they've served their sentences. These 6,000 are part of what we call drugs -2 at the federal level. The U.S. Sentencing Commission sets sentences for crimes at the federal level, absent congressional action to the contrary. And what the Sentencing Commission did was reduce the number of sentencing points associated with some federal drug offenses. And they made those changes retroactive. That had the effect of reducing by some number of months sentences for certain drug offenders. Those offenders then had to go before a judge, and it could be opposed by the prosecution, and they had to have hearings. And if a judge determined that they weren't a threat to the public and met various criteria, then their sentence could be reduced by whatever number of months. And after that process occurred, then those people could begin the process of release like every other offender. So in the popular press, I think you saw President Obama releasing thousands of drug offenders. And if you didn't read beyond the headlines, it seemed like he just picked 6,000 people and said, now you go home, irrespective of their offenses or their criminal histories or their recidivism likelihood or anything like that. And that just wasn't the case. This was a routine release of people who had served the sentence as it was readjusted by the U.S. Sentencing Commission. And again, most of these, they are not going from prison to the neighborhood. The huge majority of them have gone through halfway houses, are doing some sort of reentry program, and then they're doing what everybody else has done. So just read beyond the headlines and sort of see. In fact, some of my colleagues at FAM have been tweeting today and writing to reporters like, you guys are getting this totally wrong. If you don't understand the basics, don't write the article. So it has been frustrating in some sense, but the nuts and bolts of it are the U.S. Sentencing Commission made the changes. It applied retroactively. Some number of people had their sentences reduced to that new number based on the Sentencing Commission. As a result, they finished their sentence earlier than they would have under the old sentencing laws, and now, because of that, they get to go home earlier than they otherwise would.
Just as a follow-up, the fact that we're dealing with mandatory minimum sentencing, as I did a kind of a review about how we got to mandatory minimum sentences, it appears to me as though the groups that were in the 1970s and 1980s and even through the adoption of federal mandatory minimum sentences by under the Congress, but with President Clinton, those groups are now opposing mandatory minimum because if you look at some of the articles in Ebony magazine and some of the significant leaders in the African American community in the 1970s and 80s, they're saying drugs are destroying our community, they're destroying our neighborhood, they're destroying our youth. Now those same groups have swung against mandatory minimum. Could you talk about how we move from non-mandatory to mandatory, now we're seeking to swing back? It's a pendulum is swinging back and forth.
And that's a good way to put it. And really, like any time we get new laws and new sentences and higher sentences, a lot of it is just a high-profile event. And then politicians and members of Congress and members of the legislature feel like they have to do something about it. And so you have press conferences. We're going to get tough on this.
As a former mayor, I'm a politician, so let's...
I'm sorry. The other politicians.
Okay. The bad ones.
The bad politicians, yeah. I think that there's a tendency to want to do something. And it's not just politicians. Members of the public are clamoring at times for politicians to do something. In a lot of ways, politicians are lagging indicators. They reflect what the public wants them to do. Otherwise, they wouldn't be elected for long. So when there is a high-profile event, and there really is one at the federal level that stands above the others, and that was the death of Len Bias. Len Bias was a college basketball player who was drafted by the Boston Celtics, and soon after he was drafted, he died of a crack cocaine overdose. And this was a huge news story back in 1986. And it really highlighted the crack cocaine epidemic more than any other. And again, it was one of these high-profile events where everyone said, well, wait a minute, I didn't know this was going on. And so the president and Congress felt like they needed to do something about it. It gave them an opportunity to look tough, to crack down on crack. And so what they did was they passed new mandatory minimum sentences, again, as a way to look like they're really getting tough on this epidemic. And one of the things they did was create a disparity in sentencing between powder cocaine and crack cocaine, such that to trigger the mandatory minimum sentence For powder, it took 100 times the amount of powder cocaine as it would for crack cocaine to trigger the same mandatory sentence. Now, at the time, the reason for this, and this was supported and in fact pushed by the Congressional Black Caucus, and it was for the reasons that you cited. These are the folks who looked into the neighborhoods and said, crack is killing our neighborhoods, killing our young men, so we need to do something about it. And the conventional wisdom then was, if you want to deter some activity, impose a harsh sentence on it. And if you want to really deter something, impose a really harsh sentence on it, as if there was some one-to-one correlation between the harshness of a sentence and the deterrence effect that it will have in the community. So they said, okay, sure, powder cocaine is bad, but crack cocaine is worse, so it should get the harsher sentence, and then that'll solve the problem. Of course, it didn't solve the problem. Crack cocaine usage was roughly about the same. It didn't really drop. But what did happen, and is we're being sponsored, of course, by an organization that in part studies economics. I taught economics in high school, so if you know anything about economics, you know about unintended consequences. And one of the unintended consequences of the crack powder disparity was that huge numbers of young black men went to prison as a result, because the folks who were using and dealing powder cocaine would get comparatively light sentences, but the folks who were using or dealing crack cocaine in comparatively smaller numbers were being warehoused at tremendous rates. So this, again, this is an unintended consequence of the crack powder disparity. You see some narratives where it's intentional. I don't believe that it was. I don't think that folks set out to create a policy that had this outcome, but I don't think there's any denying that it did have this outcome. So one of the reasons that I think you see some of the groups who supported this back in the 1980s, and not everyone did, by the way. Some leaders in the black community were dead set against it right from the beginning. I saw an article, Jesse Jackson was quoted from the 80s that said this is going to lead to, I think he called it a fascist state, it's a terrible. So not every black leader was for this disparity. Some saw the potential and predicted exactly what in fact did happen. But one of the good things about having history as a guide is that it can guide us. So you look back and you say, for 30 years we've tried this. What was the result? Well, we didn't see any impact on the drug trade. We didn't see crack cocaine usage rates dropping. We didn't see teens using it at any lower rates, but instead we get tens of thousands of more people in federal prison at huge costs. So we get to look back and say, this is what we wanted to do. It didn't work. This is what we didn't want it to do. It didn't work, so now let's change it. Oh, and incidentally, the other reason for the disparity was the perception among some that judges were giving white defendants comparatively light sentences and sending black defendants to decades in prison. So they said, well, in order to reduce the disparity, we need these mandatory minimums. And the U.S. Sentencing Commission studied that and found that not only did it not fix the disparities, it tended to make them worse, and for reasons I'm sure that we'll get into later. So with 30 years of history as a guide, we can now say definitively that what we wanted to have happen didn't happen, and what we tried to avoid did happen. So now a lot of people are looking back and saying, what can we do to fix it?
You raise an interesting question, which raises my next question, because prior to the imposition of mandatory minimum sentences, there's a lot of judicial discretion. And after the imposition of these mandatory minimums, judicial discretion tended to evaporate. The question that I have and other people have is, once we remove mandatory minimums, then the discretion shifts to the prosecutor? Is that, there's a level of the public trust between, do we trust members in the black robes sitting on the bench, or do we trust prosecutors? Which group? Because a prosecutor determines the level of, and which kind of felony we're going to charge you with. You can plea bargain down to something lesser. So we have a lot of discretion, prosecutorial discretion. We have judicial discretion. Where do we find the balance in terms of achieving real justice in our system?
I think that's a good point, and a lot of people who talk about mandatory minimums and maybe even support mandatory minimums, although there are comparatively fewer of them now, thankfully, they say, we have to get rid of discretion in sentencing. Well, discretion in sentencing is a bad thing. It leads to disparities. One person gets X for the same crime that somebody could get 2-3 times X. And I think that's flawed reasoning, because you really can't get rid of discretion in sentencing. The only thing you can do is transfer it from actors in the criminal justice system. There will always be, as part of an inherent part of the criminal justice system, some discretion in sentencing. So the question isn't whether we should have discretion in sentencing. It's whether it's who should have the discretion in sentencing. If you see one of these books with the classics, Friedrich Hayek, who's an economist that some of you guys might be familiar with, he talked about central planning in the economy. It wasn't the question wasn't to plan or not to plan. It was who does the planning. And to Hayek, he thought, we should have individuals planning their own lives instead of a central government planning it. And I think it's the same thing with sentencing. It's not whether anybody should have discretion, it's who should have discretion. And FAM's position, in the position of folks who think we should have enhanced judicial discretion, is that there's only one person in the courtroom who's a disinterested party. There's only one person in the courtroom who doesn't have some sort of vested interest in the outcome, and it's the judge. A prosecutor, yes, prosecutors are ethically bound to seek justice, but the incentives built into the system often lead prosecutors to seek convictions instead of justice or whatever you want to describe it. So the judge is the only person who's armed with all of the knowledge available to all of the actors in the system, and the only person who's disinterested, who doesn't have an interest in the outcome. The judge doesn't get a promotion if the defendant spends longer in prison, right? And the judge doesn't get fired necessarily if the person spends less time. The judge is accountable to voters in most of the cases, or at the very least, accountable to some sort of oversight or procedure in a way that prosecutors are not. Sometimes, or in fact, most of the time, plea bargains are done behind closed doors. We don't know the process that led to the outcome of a particular plea process, which isn't to say that prosecutors are corrupt or anything like that. I don't think some of them probably are, just statistically. But most of them are honest people who are trying to do right by everyone. But the incentives that are built into the system, even simple incentives like avoiding being reprimanded by your boss because your conviction rate is too low, or you didn't seek the higher sentence when it could have been justified, or when it comes time to find out who's going to be promoted, you look at the conviction rates, and if yours is lower than your colleagues, you're less likely to get that promotion. So there's always an incentive to seek the higher sentence. You can go back and say, I got 20 years for this person, even though maybe 10 would have achieved the same purpose of public safety and deterrence and all of the things that we say sentencing should be about. So when you're looking at who should have the discretion, to me, at least prima facie, it should be the person who doesn't have a vested interest in the outcome and who has all of the relevant information and who can make a decision based on all of the relevant factors rather than factors that might apply only to one interested party.
Again, I don't have a position on mandatory minimum sentences. My concern is just with arresting the bad guy. But I believe, don't quote me on this, but I believe it was the philosopher Soren Kierkegaard who said, we learn backwards, but we live forwards. So we look at the back, we learn from history, but we live forward. The question I have is, in the 60s and 70s and 80s, if we did not trust, or did not trust is the wrong word, if we did not have confidence in the judiciary, in the judges to impose sentences that would protect our communities, what makes us think now that as we abolish mandatory minimum, we can all at once begin to trust them again? We're swinging back and forth, and I think it's a fair question. If we didn't trust them then, why can we have confidence in them now? I don't. Yeah.
Well, I think in part the question assumes that imposing mandatory minimums was a good faith effort that was premised on not trusting judges to impose appropriate sentences, and I think that's probably fair in a lot of cases. But it's also the case that in some of the cases, it was probably just nothing more than trying to appear tough on some sort of crime. Grover Norquist likes to make the point that carjacking is a federal crime. All 50 states have carjacking statutes. It's illegal everywhere. But carjacking was a hot issue back in the early 90s, and some congressmen thought that they could get some press time by adding a carjacking statute to federal law. So they had a press conference, they filed a bill. Who's going to vote against making carjacking a crime? No one. So all of a sudden it gets added to the federal code. It's the same thing with mandatory minimums in a lot of cases. It's not necessarily a pressing need. It's not because that we don't trust judges to impose appropriate sentences. In a lot of these cases, it's really just a way to signal that we care about an issue. In Florida, we have a mandatory minimum for a fourth offense for illegal lobster poaching, all right, which is a problem, but I'm not sure it's a problem that needs a mandatory sentence. But an interest group went to legislators and said, this is important to us. We want to show that we're cracking down on this. We want to show that this is a serious issue. So the way that they do that is by throwing a mandatory minimum in the statute. And again, no one's going to vote against that. Who wants to be pro-lobster poaching? Nobody. It passes unanimously. Nobody thinks about it again, and it stays on the books forever. But I would add that even in the cases where we don't think judges will impose appropriate sentences, of course, I think it's misplaced. I think that's flawed analysis. But B, there are mechanisms in place for judicial accountability. Most states have a mechanism by which if a judge does go just completely off the reservation, that that sentence can be appealed. And then an appellate court can look down and say, this judge abused his or her discretion and a new sentence should be imposed. That happens all the time. It happens when judges just, for whatever reason, ideologically, or they just make a mistake, which is of course possible, there is a review process in most states, and I think that there should be a review process in all the states, for if a judge does just impose some just utterly insane, inappropriate sentence, which happens from time to time, that a review panel, an appellate court, can look at that and say, that's an abuse of discretion, here are the guidelines, here's what other judges have given for the same crime, we're going to remand this, and the judge should impose a more appropriate sentence. That system, a system of guidelines and judicial accountability and appellate review, makes considerably more sense than a system that just strips every single judge of all discretion in all cases in order to avoid the mistakes of a comparatively few judges who might sentence inappropriately for whatever reason. Sorry.
No, I just have a follow-up question. I think TR sort of brought that forward. So if I can afford an affluent attorney that'll go through all of this process, what about those who don't have the funding to support an attorney that can go through, that knows wise enough that I need to appeal this? Because most of the time that group does not have the funding. So how do we work that in?
Indigent defense is a big problem in the country. In fact, the Justice Department has data to indicate that conviction rates between private attorneys and public defenders are roughly the same, but the amount of prison time that folks with public defenders have versus private attorneys, there's a big disparity there. And so I know we fund police to the tune of something like $100 billion a year. We fund prisons to the tune of something like $80 billion a year, and indigent defense is right around $5 billion a year. Most state attorneys and district attorneys' office have considerably higher budgets than public defenders' offices. So indigent defense is a real problem. And I know that it was either Charles Koch Foundation or somewhere in the Koch world, they gave a big grant to the National Association of Criminal Defense Lawyers for indigent defense, because that's a big problem. People who don't have access to, and it's not to good attorneys, because public defenders are my heroes. They do wonderful work, but they also have, an hour per defendant maybe. In New Orleans, it's 7 minutes per case for public defenders. And in a lot of other cities, it's not much better. So, when you couple poor indigent defense with mandatory minimums, you get this perverse outcome where suddenly you're arrested for a crime. Maybe you didn't do it. Maybe you think that you have a colorable defense. Maybe you say, I just didn't do this. You say, okay, well, you're facing 25 years. And the prosecutor says, I'll give you a plea deal for 5. You have 7 minutes to meet with your attorney, and you have to sign the paperwork in 15, or I take the deal off the table. I don't know what I would do in that situation. If I genuinely felt that I was innocent of a crime, and I wanted to exercise my constitutionally guaranteed fundamental right to trial, but I know that I'm risking 20 extra years in prison if I'm convicted. And when it comes to juries, who knows, right? I mean, one jury might acquit, another jury might convict, and if I'm one of the unlucky folks who gets a conviction, I go to prison for an extra 20 years. So adequate indigent defense is certainly part of the equation, and if you don't have that, if you don't have an attorney, and it's not only who can take the time to go through the facts of the case and interview the relevant witnesses and really put together a narrative that gives a defendant the best possible defense, it's also the person who can pick up the phone because they used to work with the state attorney back in the state attorney's office before they were a private counsel. A lot of these informal things that happen that you may just not be able to do because the resources aren't there. I gave a talk at a high school last week, and it was about the differences between our ideal version of the criminal justice system and how it works in practice. And everything down the line, from arrest to conviction and sentence and reentry, everything is perverted in some way, and each thing reinforces the rest. So it's not just sentencing, it's not just indigent defense, it's not just bail reform, it's not just any of these things. They all work together and mutually enforce one another to create a total perversion of what we normally would think of as a rational and functioning criminal justice system.
Let me ask you a question about the relationship. Is there one between mandatory minimums and truth in sentencing, where you have to serve at least, what, 85% of the prison sentence? Is truth in sentencing inconsistent with mandatory minimums, or is there a conflict there, or can they be both be imposed at the same time?
Some people disagree with me, and I'm sure that there's conflicting views, probably even within FAM, but I've never thought that there was an inherent conflict between truth in sentencing and judicial discretion. I've never thought that you couldn't have truth in sentencing along with no mandatory minimums, which isn't to say that truth in sentencing is a good policy necessarily. But if a judge who, again, has all the facts of the case and sentences a person to X number of months or years in prison because that sentence makes sense to the judge, then I don't think that there's an inherent conflict in making the defendant serve some percentage of that sentence. I don't think that's in conflict with judicial discretion. Again, some people probably disagree, but if a judge says you deserve 5 years and here are all the reasons why 5 years makes sense, I say you deserve 5 years. It should be 5 years is an appropriate sentence. And here are all the reasons why 5 years makes sense. Well, if the laws in the state allow that person to, say, get out in 1 year, that actually might increase the sentencing error there, whereas maybe 85% for that defendant makes more sense. So again, it's not to defend 85% or truth in sentencing, but I don't think that there's an inherent conflict between judicial discretion and truth in sentencing. I'd add that in Florida, we have 85% for every inmate, no matter what the crime. You know, first offense, nonviolent drug crime, 85%. First degree murder, 85%. So actually, I don't think that first degree murderers get 85%. But whatever, you get the point. There's no distinction. They all have to have 85%. And I always want someone to file a bill that allows first-time nonviolent drug offenders to serve 84%, just to see what the reaction would be from the people who they defend 85% as if it's sacrosanct. I just want to see if we just reduced it 1%, what would the reaction be? But we probably won't get that bill.
An additional question I have deals with the issue of recidivism. One of the reasons that we opted, or as I read, moved to mandatory minimums was to ensure that people were assigned to jail, they were going to stay there, and we have a recidivism rate of what, about 68%, something like that. How do you balance protecting the public versus the rights of the individual who may have been the victim of disparate?
Yeah. Well, first, actually, there's an article today about a study that was done that calls into question the 68% number. I'd never seen that previously, that had been called into question, but at least there is some indication out there that that number might be inflated. But let me just be clear that my interest in mandatory minimums is not to make sure that criminals get out earlier than they should. In fact, I have no interest in that whatsoever. I don't really care if a violent criminal has to go to prison to protect people from that person's violence. To the degree that incapacitation will protect the public from a person who otherwise would prey on it, then incarceration makes sense. There's absolutely nothing, at least in my position, that calls into question incarceration per se. I think that there's a lot of value in incarceration, particularly for violent offenders, and particularly for violent offenders who are in a certain age range. We just know that between 18 and around 30 to 35, young men are particularly violent. And if you have someone who has shown a propensity for violence, incapacitation very well might be the only way to protect the public from that person's future crimes. The question is not whether any given person should get out or what the sentence should be. It's my position that we can't know the right sentence for all categories of crimes. We can't know that just because a person was convicted of this category of crime, that this sentence here, by definition, makes sense. The position is that we have to, that there's dispersed knowledge in this, that there are factors that nobody can know when they're passing a sentencing law in the legislature that impact recidivism and whether a person is going to be violent again. Or, these factors impact what the right sentence should be, and we can't know them ahead of time. The only way to know that is to run it through a judge who knows all the information, who can say, okay, this person is X years old with this number of crimes in his past. This was the crime he was convicted for, and then run all the demographics and things and say, because of that, this is an appropriate sentence. It's the only way to minimize the errors in the system, and that's really the only thing we can hope to do, is minimize the errors in sentencing. You can't get a perfect system. You just can't. You're going to have sentences that are too long, you're going to have sentences that are too short, and there are going to be errors no matter what the system is. The only thing we can do is design a system that reduces the number of errors in sentencing. And you reduce the number of errors in sentencing by maximizing the knowledge available to the people who are doing the sentencing. And mandatory minimums take no knowledge into account. They're centralized sentencing schemes that say that only one factor matters, the crime for which you're convicted. Whereas in a system of judicial discretion, you have significantly more knowledge available to the sentencing actor. You've got all of these variables that we know impact public safety. And only when you use that knowledge effectively can you design a system that will reduce the number of sentencing errors. And I think that's the overarching point.
I have a question. As I've talked with individuals about mandatory minimums, the perception is that mandatory minimums are primarily at the federal drug courts, and that's the realm for most mandatory minimum sentences. Is that correct?
Well, it's certainly true that the federal government has its fair share of drug mandatory minimums, and about half of federal prisoners are in prison for some sort of drug-related crime. A good number of those are serving mandatory minimums, or at least they faced mandatory minimums and had to plea bargain down. But the huge majority of prisoners are state prisoners. We have around 2 million people in prison. It's around 200,000 or so in the federal system. The rest are in state prisons. So the majority of the problem in mass incarceration, or however you want to describe it, is at the state level and will require state-based solutions.
That raises the next question I have dealing with, you may or may not be aware of Missouri. Some of our minimums, and if you're not, you can talk about other states. But in Missouri, we have Class A felonies, which are primarily murder, first-degree kidnapping, forcible rape of a child under 12, first-degree robbery, and some drug cases. Class B deals with voluntary manslaughter, first-degree burglary. Then we have Class C and D felonies, but we have mandatory minimums for Class A and Class B felonies. As you look at the issue of mandatory minimums, and we have 50 state governments with 50 different definitions of crimes and mandatory minimums for different levels, and we have the federal system. Could you kind of speak to the, I guess, the highly decentralized nature? How do we move forward with our understanding about mandatory minimums and their impact? And you have 50 different states with 50 different definitions, and we have the federal concept on top.
Yeah, well, call me one of those folks who appreciates the laboratories of democracy. I'm glad that we have 50 different states experimenting with these things. Missouri knows its state better than somebody from Florida would know Missouri. I think we in Florida would know our state better than most of you folks in Missouri. I know that we don't really like it when other states tell us what to do, and I'd imagine that most other states don't like it when either Washington or some other state comes in and says, this is how you should do it. And in part, this is a principle that animates me on this, is that we should have local control over the things that affect our safety. And when it comes to mandatory minimums, this is yes, it's great that Missouri or any other state is going to impose sentencing laws for its state, but even then you're talking about centralization of sentencing, unnecessary centralization of sentencing, because it might not be the case that every single crime that's committed under Class A or B needs that particular sentence. And the people who know best about what a community needs are the people who live in that community. You know, in Florida, at least, we elect judges, and even in states where they're appointed, we at least elect the people who appoint them. And so there's always going to be accountability at the sentencing level for whatever, however it's going to be. And the people who, if you want a particularly tough judge, they can elect particularly tough judges. You know, we live in a time where we have virtually unlimited information, if we want to get it, about the sentencing habits of a particular judge. And surely if there's a race and there's a judge who is abnormally lenient or abnormally harsh, that's going to come to light, and voters can make their own decisions. One of the problems of mandatory minimums is that it takes away those distinctions among judges. We don't know which judges would do X or Y because they all have to do Z. And so voters are denied information that they otherwise could use in determining who they want on the bench imposing sentences in their communities. So, yeah, I think the worst possible outcome would be if Washington just told every state, you can't sentence the way you want to sentence, you have to do it the way we tell you to do it. But it's only marginally better when a state imposes a sentencing regime on local communities that might otherwise have different values or a different way to approach the problem. I think we should allow voters to choose judges and to choose representatives and sentencing actors, state attorneys as well, who reflect the values of that community, and it shouldn't be imposed upon by the state capitol or Washington, D.C., a solution that they might otherwise reject.
In the moments that we have left, is there a question or two from the floor? If somebody does, maybe come up to the microphone so we can record it. Anybody have a question you'd ask of our panelist?
That means I did a great job.
Just come to the microphone if you would, please, ma'am. If at the back, if you have a question, you could just come and stand by the microphone.
My question is, with the violence and the violent criminals, no one has ever stopped to think or checked to find out if the person is mentally ill. So they go in mentally ill and they come out mentally ill. So this creates a revolving door for the mentally ill. No one is thinking about that, and no one really cares, I don't think, because of the conditions and the populations of the prisons. The same thing with the drugs. Mandatory this, mandatory that. They go in because of being caught doing something illegal with drugs. They come out, the drugs are still there, so they do something else illegal. It's a revolving door. It's insanity. It's insanity. Until we do something to correct some of these problems, we're going to have a revolving door and a bunch of insane people that's supposed to be professional.
I mean, I would tend to agree that mental health is a big problem. We've shifted away from mental health treatment, and we're using county jails as a proxy for controlling mental health. And a lot of times you can keep these folks in there for a few days, and you just send them back out, and they don't have any sort of structure. It's hard to get medicine, and like you said, it's a revolving door. And, you know, prisons are appropriate for some things, and mental health facilities are appropriate for other things. And the degree to which we use one for the other, we're going to have errors in the system, and that's going to create all sorts of problems. If we use mental health facilities to house violent inmates who should just be incapacitated, that's going to be a problem. If we use jails and prisons to house folks with mental health problems who would otherwise be better off in mental health facilities, that's going to create its own set of problems. So yeah, I mean, again, this is one of those things where there are a dozen things, and when you start talking about any one of them, it creates half a dozen others. And it's an onion with 100 layers, and you just have to peel back one by one, and every time you peel one, you have another one that you have to peel back. I hope that we are. Yeah.
Well, the issue is really complex, because as you raise the issue of mental health courts, it's also tied to drug abuse as well. And one of the problems that we have is that we've tended to use jails, especially at the municipal or the county level, as mental health treatment facilities. People are locked up for a few days, and then they're released, and it becomes a cycle. One thing that we're looking at in St. Louis County is trying to expand and develop a good mental health court system. But that takes a lot of resources. That involves training of officers, training of individuals. It's a commitment of public resources. And that's a long-term issue. So I think once you peel one issue back and say, we need to deal with mental health in terms of individuals that are incarcerated, treatment, recidivism, costs, everything is related to everything. And it really is a very difficult public policy issue. Let me get your question.
Having worked as a criminal defense attorney previously, your comments concerning federal sentencing guidelines and the centralized sentencing scheme are particularly well taken. So my question is, often in Washington and even on the state level, you have solutions in search of a problem. How did sentences occur prior to 1986? What did they look like after 1986? Were they shorter, longer? Did they actually in the aggregate change that much?
The sentences are longer at the federal level post-1986. And I forget by how many months, but they are statistically longer, statistically significantly longer in the post-mandatory minimum world than the pre-mandatory minimum world. I wish I knew by exactly how much, but we are reasonably confident that they are statistically significantly longer. And some people dispute that this is what's driving what we call mass incarceration. There are folks out there who say that, well, sentences aren't really the problem, but that's the minority view. The majority view among criminologists and people who have looked at the issue can sort of pinpoint, here's when we started really focusing on making sentences longer, and here's what's happened to the prison population. And even though they're just two variables, most people have come to the conclusion that changes in sentencing law have really meaningfully impacted the prison population.
Thank you.
I would like to follow up on the question that the young lady had. Also, you talked about the young people or whoever's in there because of a drug issue, and they come back and they're back to selling drugs. Unless we can provide an alternative for them, such as a job or education, because that's what it's going to be. If I need to keep the lights on, feed, support my family, I'm going to go back to what I think I know best. And until we as a society, and also, I'm big on, what's that line? Have you ever been convicted of a federal crime? That in itself is a barrier to these folks who come out trying to start a new life. And so we've got to even look at that as well.
Yeah, there's the big ban the box movement that's
Yes.
going on now, and I know President Obama is making a move on that for federal jobs. Koch Industries was one of the first major corporations to ban the box in their hiring practices. And if you're not familiar with ban the box, it basically just means that when you ask about criminal history, you do it later on in the process, in the hiring process. So if,
If you do it at the beginning, or if you do it later on. I know you perform an opinion right there in the middle of the individual, but really, does it make sense?
it does, apparently. If you look at the numbers, there is some sort of statistically significant impact between asking at the very beginning of a hiring practice and asking later. Because if you ask at the beginning, the resume just goes right in the trash. But if you ask later, you give them a chance to interview, you get to know them a little bit better, and then when you realize that they have some sort of criminal record, in context, it doesn't seem as bad. Apparently, that's how it works. So, well, I mean, if you...
Well, let me get to the gentleman's question. Yeah. Get your question. Yeah.
You two can dialogue afterwards. All right. With that said, I want to go back to thank you, panelists, for stepping up and help to enlighten us. But Ruby, you kind of pointed out something in regards to the convoluted network of barriers that these vulnerable individuals will be faced with. What I'm questioning today is you brought up, I think it's Mr. Newbern, you brought up an issue about consequences, and Mr. Carr, you brought up a term called discretionary. So if we look at this, looking at discretionary consequences and looking at collateral consequences, how do we justify, or how has minimum or sentencing grappled in that area with those two?
With collateral consequences?
Collateral versus discretionary, yes.
Well, we certainly know that there are collateral consequences to arrest and serving time in prison beyond just the fact that you were arrested and the fact that you're serving time in prison. I guess I would argue that a system of judicial discretion can reduce the collateral consequences of arrest, if only because we know that folks who spend more time in prison than they need to have have more of those collateral consequences, right? I mean, it's harder to get a job if you've been in prison for 10 years than if you've been in prison for 2, just because technology has changed. The things that were important 10 years ago are no longer important. We've got folks who've come out of prison and they've never seen iPhones, never seen iPads. They don't know, they've never seen these things. You know, yeah, cell phones. They don't know how to use these things that the rest of us take for granted. And that's a meaningful collateral consequence. You know, not only, it's hard to find a job, but you don't know how an iPhone works, right? I think a lot of that is more in state prison than even federal prison, but it's a real thing. So when we're talking about tailoring sentences for people, you reduce those sorts of collateral consequences when you sentence someone appropriately. If someone can stay clean and stay out of a life of crime after 2 years, and that sentence is appropriate for all of the other things that we value sentences for, you know, just incapacitation, general deterrence, punishment, which is itself a value for certain crimes. If all of those things can be achieved in a sentence of 2 years, and a mandatory minimum requires a sentence of 10, that's 8 years of someone's life that's just wasted. It's 8 years of a time when they can't be learning a new trade or going to school or bettering their lives in some way. And that's a tremendously huge collateral consequence, and it exists only because of the disconnect between the appropriate sentence and the mandatory minimum required by law.
We want to, as our time is drawing to a close, I want to thank all of you for being here. We do appreciate the fact that we've been able to discuss a significant issue in a civil manner, because these issues are very, very difficult. They're on the political agenda, they're on the policy agenda, and they affect all of our lives. They affect the lives of men and women who are in jail, of children, and they affect the perceived safety of individuals and the well-being of our community. So one of the issues facing us is, how do we move forward? And I don't know the answer. I don't know that AmFam has the...
We do.
Well.
We do know the answers. They're all at fam.org.
But again, thank you much for attending this afternoon. I know we have another session that starts in just about 5 or 6 minutes.
You said what we can do
Ruby?
to move forward. I would closely look at the folks who are running for political office, and if they don't support the mindset that you have in terms of a lot of issues that affect our community, I think about who I'd vote for. You can win it at the polls.
Well said.
All right. Thank you.
Thank you.